Court does call the case of Fixing Housing 401k Plan versus Erica Ward et al. Counsel, state your appearance.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing 401k Plan.
Your name?
Good afternoon, Erica Ward and Aaron Ward, on behalf of ourselves.
All right. All right.
Your Honor, I believe my client representative, Mr. Hawk, is participating over Zoom.
Is
I think he is on his iPad.
iPad 4. I'll need you to unmute, state your name, and turn on your camera if you're participating in these proceedings.
He did actually post in the chat as Mr. Hawk previously. But I can't don't know that it's there now.
All right. Posted in chat is there. We'll need to.
Yeah. That was at 2 seconds.
I'll need visual confirmation. Otherwise, they have to get out of Zoom. All right, this date and time set for a couple of things, but mainly the motions in this case. All right,
Yeah, ready to go. The motions.
you ready to go?
Yeah.
All right, go ahead.
Your Honor, I'm not going to belabor the points that I've been making at multiple hearings. The lease expressly provides that tenants must pay monthly base rent of $5,500, quote, without any deduction or set off whatsoever. That is paragraph 3 of the lease. As the court correctly stated back in November, the lease language is not conditional. That transcript from that hearing is Exhibit E to our motion. Your Honor, tenant's sole defense is that the lease is actually residential, is frivolous. Tenants admit in filings with this court and the circuit court that they are operating a commercial horse sporting farm on the property. Tenants don't reside on the property, and it's a business collecting money from the boarders. I quote from their circuit court complaint, this is paragraph 2. Erica Ward leases the property to conduct her business. Willow Ward Equestrian LLC allowed on the property by the lease and Scioto Township regulations as an agricultural/farming use. Erica's business is an equine boarding and training facility. This court, again, back in November, acknowledged the commercial nature of this lease dispute. Tenants argue that the lease does not use the word commercial. It does not use the word residential. It is a 7-year lease ending April 2028. Paragraphs 4 and paragraph 8B of the lease supports that it's a commercial lease. In the circuit court, tenants individually are bringing a business interruption/tortious interference claim against landlord, seeking alleged lost profit damages. So tenants are seeking alleged damages to their business on the property under the lease in the circuit court, while conversely arguing that the lease is residential in this court. Tenants signed a lease and guarantee. Landlord brought a guarantee claim in circuit court. The separate guarantee agreement further evidences the commercial dispute.
Where's the dates? Go ahead.
Your Honor, Michigan case law provides that tenants may not withhold rent for repairs in commercial context. And I've cited these cases many times, the Rayum case and the Detroit Marine Terminals case. They provide in a commercial setting like this, the landlord's covenant to repair is independent of the tenant's duty to pay rent. Thus, any money claim for breach of the landlord's covenant cannot be set off from the rent that is due, and that's from the Detroit Marine Terminals case. Your Honor, I know that tenants have filed additional filings yesterday. I believe they also help my case.
Did we receive documents yesterday?
Yes, there.
I simply filed an account.
On the front. Got it. Okay, I see those. Okay, go ahead.
Your Honor, just give you context, I received an email from Ms. Ward sending me pictures of the pages of these filings last night at 7 o'clock. And just received copies of these filings in this courtroom today. They reattach Ms. Tope's affidavit, which was the reason for the show cause hearing. I can dig into the substance of Ms. Tope's affidavit, but none of that changes that the lease says what the lease says. And they did not have the right to withhold rent. And actually, there are paragraphs in the affidavit that support my position. If you want me to go through those, I can.
No, I don't know that that would be necessary, quite frankly. But go ahead.
Your Honor, and their only defense is that this is actually a residential lease. There are no grounds for that. Please grant our landlord's MSD. Thank you.
Your Honor, actually, that is not the case. For the past 2 weeks, based on review, we fully understand that the lease has been deemed a commercial lease, and that under a commercial lease, you cannot withhold rent. However, we believe our motion for dismissal with prejudice should be heard, and that their entire basis for their summary disposition, or the request for summary disposition, is based off of a retaliatory lease, based off the fact, and I have emails.
Retaliatory lease.
Retaliatory eviction. He sent me an eviction notice within 7 days of replacing the water heater, which, Your Honor, he continuously says that we made a unilateral decision to replace the water heater when I have documentation, which unfortunately I just thought of showing you this and I can't because I didn't submit it. But he knew about the water heater. He told us to have someone come out. We had the professional come out, and we submitted our June payment of $2,800 after fixing this, because the professionals told us this is a 30-year-old water heater. There's a gas leak. It's toxic and it's dangerous. So there is a statute under MCL 65720 that states they cannot evict me within 90 days of me going to them requesting things that are, as he stated, the lease says what the lease says. Granted, regardless of whether it's a commercial lease or residential.
But you're quoting the retaliatory eviction statute.
Yes. Because their whole case, they're requesting summary disposition based off of a case that an illegal case that they're bringing against us. Because it was June 1st or 2nd that we notified them. Ma'am,
read that statute and tell me the language in that statute that you believe is applicable to this circumstance.
If the landlord started the eviction proceeding within 90 days after we, the tenants, tried to enforce our rights against the landlord who did not respond to fix a dangerous, toxic, fire hazard gas leak in the residence of the property in June, I informed the landlord of the hot water tank, that it had not worked, and that.
Slow down. So you're saying you informed him of it.
And he told us.
But he told you to repair it. Right? He gave you permission to repair it, you're saying.
He gave us permission to have a professional out.
Okay. And
that did nothing.
But what did nothing?
And then no more communication until the 13th, when I got emails telling me that he was replacing me, the bar manager. I couldn't collect my board anymore, and all kinds of other craziness. Best way I can describe it. On the 13th. And so that is when I got a lawyer and I filed suit in circuit court against him on July 9th for breach of lease for many.
So you think that the reason that they're here in this case is because why? Because you sought to enforce your rights?
Yes, it's a retaliatory eviction, absolutely.
But I think you need to look at the retaliatory eviction statute a little bit closer and look at the cases under it. I don't see this as a retaliatory eviction case at all.
Okay, so I'm sorry, but I haven't really heard, was that his motion for summary disposition that that's the same thing I've heard. Is that what is
Yeah,
that
I mean, he's basically saying the lease says you can't withhold.
absolutely, and that's fine. And if you were to grant summary judgment, then we would absolutely pay back the back rent minus, this is why I submitted this account.
Oh, but minus what?
Well, the things that he's responsible for in 6A and B of the lease. I've been asking him for years, since 2022. At a minimum, there's enough information to do discovery and have it heard before a jury.
I think jury at this point on this case at least is waived, so I don't think
Or-
that's gonna happen.
A trial.
Well, you can have trial maybe. But basically, ma'am, these are counterclaims for for payment under other provisions in the lease.
Correct, 6A and B, where it states that he needs to do this and respond within 48 hours.
Okay, but the bottom line is you would still owe the money, but you're saying that there are offsets or money that he owes you.
Correct. And it might, like you said, the law is the law. And Your Honor, but there's also justice. And so I don't believe that I've breached the lease because I'm willing to pay back the back rent. I mean, I've been paying into an escrow, which I understand that was a wrong process. So that put us in a bad spot. So moving forward, we've put it in escrow with the court, as you, Your Honor, told us to do. We've never not paid rent.
Okay. Anything else you want to tell me?
Well, again, I guess I'm just asking you to consider that if we have to pay the rent that went towards repairs, which basically is investing in his property, yes, I would ask that you would.
Well, but you don't, hang on a second. Let me ask you this, Ms. Ward. There would be a difference between you paying rent, right? I mean, sometimes the way that these things end up in litigation is if you had paid all of your rent, but then these repairs weren't done, what would you have done?
Well, now I understand what I should have done.
Is
file-
what?
Pardon me?
Is what?
Is file a lawsuit against him and had you direct how to spend the money. Correct.
Well, I could have done that if it got to that point, or I could direct repairs be
Right.
made, or whatever.
Right. I understand
Okay.
that.
So in essence, what you have here is a counterclaim for these things.
That's what I'm asking you to consider. Yes, Your Honor, but obviously that's in your hand.
Yep.
I know, I say the obvious.
But in terms of the crux of their motion, that they're entitled to their rent without set off, you would agree with that? If you
Based
look
on the
at,
law and the research that I've gone out and done on my own since I dismissed my lawyer, or she withheld, whatever you call it, then yes, I personally still think it's great. but
so
I
then
can't-
just tell me this. Tell me any reason you believe I should not grant their motion for summary disposition as to liability.
Can you say that in another way? Because I know summary disposition, what do you mean as to liability?
Meaning,
Whether or not.
I make the legal determination that they're right, that they're entitled to their rent without any set-offs. Now, that may not resolve what are your counterclaims.
Because without any set-offs was not even in the lease. The without any set-offs was in a separate document, which was a guarantee, which I also think is, if not illegal, definitely shady, telling me, okay, I'm not a commercial person. I mean, I had a friend who's not even a landlord tenant lawyer review this for me before I signed it. Okay, that's my fault, but he had me sign a guarantee completely not even in the lease. that says no set-offs. The no set-offs, as far as I read in the lease and what I was going to was section 6A and B. So I didn't know what else to do when this landlord is refusing to do anything, to repair anything. And I have all the documentation asking him about it for well over since 21, actually. So the no setbacks is not even in the lease. I guess that would be what my contention would be.
So are you saying then that you have the right to set off?
I'm saying you have the jurisdiction to make a decision, but yes, I do think it's gray. I think the whole thing is very suspect. I mean, we did, obviously we filed a breach of lease on July 9th. And then it was in October, he's evicting me, and I paid the full.
July 9th in circuit court.
I filed in circuit court.
Right.
A breach of lease for all of the stuff that he's done.
And you're saying that because of your filing, this is retaliatory?
Well, it's retaliatory based on the first time that I spent my rent money on having this fixed, which he told me to have professionals come out and look at.
But
hold
on a second. Hold on a second. That isn't retaliatory.
Well, he told me to have the furnace the water heater looked at.
Correct.
I got it fixed, and then 7 days later.
But hold on. He tells you did he tell you to have it fixed?
Let me know what they say. And when a professional comes out and says it's.
Okay, hold on a second. So he tells you to have the furnace looked at and let me know what they say. So hold on. So did you then let him know what they said?
I paid while they were out there because they said to do it immediately.
So that's a no.
But he had established a process over the years. It's a no, Your Honor. Correct. You are right. It's a no. But over the years, he had me hire. He finally, after months of asking him, I got an electrician out. He refused to pay the electrician. And we even said in the email.
But you have to slow down. You're jumping around.
I know my heart rate's at like 140.
So but you keep talking about this retaliatory nature of things. And what I don't see this as a retaliatory eviction.
I don't, okay, then I'm not a lawyer, but for whatever reason, I've always paid my rent. He has set a precedence of saying, yes, fix this, go ahead, keep it out of your rent. I have done it 3, 4, 5 different times over since 2021. I'm not a commercial entity, regardless of the stupidity.
Okay, but here's the thing. If for a particular portion, you're saying that there are previous times where that's occurred. And those previous times, right? There was, in essence, an agreement in writing to deviate.
That's true.
Right?
After months of
Okay,
saying,
okay,
this
okay.
guy. Correct.
So that both parties at that point agree that we're going to pay this, and then this is the amount of the rent we're going to send you. Right?
Let me concur. Yeah, that's true. He did not ever, he never sent a text that said, go ahead and take it up. There's multiple times it's happened. On occasion, he said, fine. Other times, he just ignored us. He ignored me for months at a time.
Okay,
and then
he ignores you, but what do you mean by he ignores you?
Can Aaron comment, or am I?
I don't care who,
Okay.
He's part of this case too.
My wife saw an established process. We had a furnace go out.
Okay.
And have someone come out and fix it. We did. The plaintiff refused to pay him. I sent him several messages. I called him saying, please pay the person who deserves to be paid, or I will take this out of lease. I never heard from the plaintiff. We took it out of lease.
And hold on a second. And what did he do because you took it out?
Nothing.
Right.
It's happened 3 separate.
So now on this occasion, right? Did he tell you to fix those things?
No, Your Honor, but I.
So hold on,
No,
because
I
you're
understand.
gonna have you've got a very different circumstance.
I believe we were just following the process that is established where things got fixed. We took out lease gas leak. I understand what you're saying completely, Your Honor.
It was a gas leak. I thought it was an emergency repair.
The process had been, it gets fixed, we take out lease, it happened to be.
Well, that's the process where he says, fix it, have it fixed. Then the person you're saying is not paid, it doesn't matter to me about that necessarily. But at some point, you then take it out of the payment you're sending him because you've done it. But at the crux of that is him saying repair it. What we're talking about now, that didn't happen. That first part, right?
Correct.
You were just saying, I have a problem. He doesn't respond, may not respond, doesn't do anything, or says, have somebody come out and look at it and let me know. You then decide to sort of jump ahead, you repair it and then take it out. And what I'm indicating to you is, I don't think you can do that. The party certainly can deviate. If it were an established practice that you would just make any repairs that you thought necessary and then send him the balance, and that's the way it went, that'd be one thing. But that's not what this is. The distinction is, he says, because he has an obligation to make some of those repairs, he then says, just get it fixed. And then ultimately you take that out. And I think rightfully so, then when he said fix it, he doesn't complain about what she did. But it's when you do it differently that there's going to be the complaint.
I
No.
can't argue with you there.
You can argue with me all you want.
But you wouldn't listen anyway, but I know, I get it. I
The
understand.
reality
You
is,
shouldn't.
we're in a tough situation with a gas leak.
I
Unfortunately, people
thought-
know tenants are not paid, so we have someone who knows if they're not going to pay, we need to get it fixed, and we thought we were following the process. I understand it's tough. It's very, I just.
Don't think it justifies an eviction, and he wants the 2,800.
Well, and it may not, because understand that although this is a termination, I'm not clear that termination is necessarily going to be the result.
Well, that would be great.
Well, I don't know. I haven't made a decision. I haven't heard it. The issue on their motion for summary disposition, I think it's the liability for the rent, liability for the breach. Yeah, but I can just certainly decide on the remedy, which is why I was trying to get to the parties to have them understand that I really think the parties need to resolve this.
I felt we made a very fair settlement offer.
Well, I don't want to get into that, but I really do think it should be. So as to the issue of rent liability for breach of the lease, but not as to damages and remedy, I'm going to grant the motion for summary disposition. As to the amount of damages and as to the remedy to be applied as being a summary proceeding, the court will make a later determination on that.
Say that one more time, maybe dumb it down a little. I got that you found in
They
favor.
win on, yes, I find in favor that the lease is interpreted in the fashion that plaintiff wishes it interpreted, and that is that you're not entitled to an offset for monthly rent. It still doesn't resolve the issue, and I don't know that we've gotten that far as to the issue of what repairs needed to be done, but they're not going to face liability for repairs that you made without their approval. That's probably going to be the practical effect for you. Get that? You're looking at me like you didn't understand what I just said, but I'm more than happy to explain what I'm doing. But
Oh.
You got it?
Yes.
Okay.
Your Honor, there's many things I'd like to respond to, but the breach of the lease is the grounds for the termination.
I understand that.
And that's why we're here to evict them. Your Honor, regarding any counterclaims, they have not pleaded any counterclaims. They filed an answer. They didn't file affirmative defenses. They didn't file counterclaims. That was when they had assistance of counsel. So any alleged counterclaims that they have should be deemed waived. And it's also the same thing why they rushed to court and filed in circuit. So I don't think there are any questions of fact as regarding their damages. They're trying to seek damages through motion practice.
I understand that. I understand what you're saying, but you're also requesting a money judgment along with just termination. You're not just seeking possession, right?
Yeah, we're obviously asking for the money that's owed.
And what I'm saying is, I'm granting it as to liability that there's been a breach. The court possesses a great deal of latitude with what the effect of that breach will be, and as to the issue of liability. And I think the issue of liability, well, the issue of damages, which still would have to be decided by this court, may be up in the air. If there were repairs that needed to be made, it wouldn't be an offset on rent. They may have breached in that regard, but they may still be entitled to certain repairs which weren't done that they did from a monetary standpoint, not from a breach of the lease standpoint.
I understand that, Your Honor, but they would be off of counterclaims that they have not.
You can make that argument. I mean, but we still have to have damages here. So, because I haven't ordered damages. So there'll be a damages here on it.
Would the court entertain releasing any of the escrow because they have defaulted on the lease?
I think that if the parties, I would strongly consider it. If I felt there were good faith opportunity or good faith to try to resolve that portion of the matter. I mean, and I'll just put it this way. I think there was a timing of move out that, and I'll be blunt about it. A timing of move out to move livestock during the winter is cruel. It can be done, but there are a lot of effort. Livestock have to be moved to a different location. Then it's really best done in the spring. Or, well, really summer's not a great time to necessarily do that either. But I think the parties are certainly at a point that it really is an issue of move out. Paying and then moving out. And it's just an issue of timing, as far as I see it.
I mean, Your Honor, we were the first ones to offer a settlement offer, which was rejected.
And counsel, I'm not saying that you haven't. I'm just saying it's really an issue of timing. I think they're going to be better off being someplace else. I think your client's going to be better off having that property. It's just how many horses do you have there?
38.
38. It's how and what is a proper amount of time to move those 38. That's really the issue as far as I'm concerned. Yes.
If it's possibility that they could buy the business if they want.
That I'm not getting.
I don't even know where all
I'm not getting.
even go. Okay.
I'm not getting into that. I'm saying that if you had to move them, let's put it this way. The court said right now they breached this lease, their tenancy's terminated. I set the writ date. It's not going to be 10 days. And so I would suggest, given the court's ruling, that the parties be reasonable about a reasonable time to vacate the premises. Not too long, not too short. Otherwise, what's going to happen is, if it gets down to that point, I am going to make that decision myself. I don't have a problem making that decision. And it's not going to probably be good for either party. That's my only point. Okay. All right. Counsel, did you, I did not see it, and I don't know if you filed it, a bill.
I did not
Time.
file. I did not file it because there was a moratorium on not filing, which I was filing.
Yeah, understood.
I have that here. I think it should be increased because they filed something yesterday,
Yeah.
which I had to review their pictures and then review the filings today in this courtroom. So I think it should be subject to an increase.
Well, here's what I'm going to do. Hold that, because Miss Tope is not here. And that was going to be part of the,
I did find my emails if you want them.
your emails.
You wanted to know exactly whether I knew ahead of time or not,
Knew ahead of time of what?
that she filed something. You had asked for them at the last court, and I couldn't find them on my phone. I don't know if you want them or not.
Well, did you know?
After the fact.
After.
Yeah, which is what I told you, but you had asked.
No, I
Right, okay,
understand what, I figured that to be the case.
okay,
You told me that. I
Right.
took you at your word for it.
okay,
I believed you,
Good.
which is why I set the show cause,
okay.
because it was filed on your behalf without your knowledge.
Correct.
Okay, that was my point, which is why then I set the show cause in part for Miss Tope, because she's no longer the attorney of record. Now, in regard to that show cause, and why I'm going to tell you to hold that, and you may be able to add to it at some point, counsel, but I issued an order to show cause to Miss Tope on, what date was that? That was on January 20th. I set the hearing for today. Show cause was sent out. The 14 days was given, as best I could see from the file. It was certainly sent out. It was sent down to the clerk's office and mailed out. We then, where's the email? Just want to get the.
This is from her, my emails.
Okay. We then get, and I'm going to say this a little bit backwards. We then get a email from Miss Tope, and it's entitled 2 p.m. show cause today. And it's addressed to my judicial coordinator. And it says, hello, I have not gotten any notice at my address or email for the show cause deed tow. You show scheduled for today at 2 p.m. on Judge Simpson's docket. I do not know anything about this. I have not had any contact from the court about it and am unable to attend. That's what she signed. So that I can make the record clear. A notice to show cause was sent by the clerk's office. When I'm looking at the file, the process that the court follows, I sign off on the order to show cause. It's sent to the clerk's office and then sent out to the parties. That happened. Additionally, and it's odd that we received the response today, and I'm sure all of you probably would have seen this process in one form or another. But on January 27th, the first version of the docket, which is set for today, would have been sent out by email to the parties. You then get an updated version. I think it's the initials, and the updated version was sent out on January 30th to the parties, which would show it's scheduled. You're looking at the time. Then the day before, because things get moved around and whatever, we send out our final of it. For Ms. Tope to say that she had no notice of it or anything along those lines is just patently false, because I have the emails of those various dates, the 27th, the 30th, and the 2nd, where Ms. Tope is emailed directly at her email address showing this to be scheduled. So it is once again a delay on her part to not show up. I will go further to say that she consistently flaunts this court's orders by, when she's off of a case, filing documents. I don't mind the parties when they want to argue with the court, but the disrespectful manner in which she has argued before this court, some people show their disrespect in different ways, but it's always noted with Ms. Tope, she is a member of the bar of this state. I do not take lightly issuing show causes against attorneys in the first place. Don't like to do it because usually, because they are officers of the court, I can command them to be before the court at whatever point I want them to be before the court. But her behavior to this court is, for a member of the bar, is atrocious. And what I think, at least as I've seen in 2 cases, predicaments which she has put individuals which she alleged to have or was representing is also, from my perspective anyway, atrocious and highly unethical in terms of some of the ways that she's been proceeding. So it is with great dismay, but when an attorney or someone tells me I'm not appearing, I know they've had notice of it and they refuse to come before the court. The court is only left with one other option, which is its ultimate way in which to compel someone to appear. And so I'm going to issue a bench warrant for Ms. Tope's arrest. Her bond in this case, your approximate bill, counsel, what's the approximate amount that you have at this point?
Your Honor, that I have at this point is $6,975.
Good enough. So I will issue a bench warrant. Bond will be set in the amount of $10,000 cash and or surety. That warrant will issue immediately. So that you know what will happen is, and I have a feeling we will catch up with Ms. Tope very quickly. Once that hearing is then set, she is not in custody and hasn't posted bond, we will let counsel, we will let the parties know. At that point, I would like to see the billing.
Okay.
All right.
Yes, sir.
You follow what I'm indicating on that?
Yeah.
Okay.
Pilot before.
Pardon?
At that.
You
time,
can
bring it at that hearing.
bring it at that hearing with the amount,
Okay.
and then I will go from there.
Okay.
Anything from you guys?
I just need to know where I'm supposed to be next.
We need to set another date, but council, if you'll prepare an order consistent with the court's ruling today, I will set a hearing on damages as well as what will be the court's enforcement of its, the motion for summary disposition. When
How far would you like to go? So we have the 17th of February or March 3rd.
you don't want to be here the 17th, I'm gonna just tell you, it's gonna be an ugly day.
Yeah.
So I wouldn't do that to you guys.
I'm sorry, what were the dates again?
And my next date is what, March 2nd, March 3rd. 30 days from today.
March 3rd, we're flying back.
Pardon?
On March 3rd, we have to be flying back and see my mom in Texas.
Possible to get a different date?
Well, it's always possible, but
March 10th.
it would be March 10th. That's a ways out, but I think that's what I'll go with. If those are my options. So I'll
Would you
adjourn.
be able to go Zoom? Well, no, we'd be on a plane.
We'll be, no, that's the problem. Maybe we can't, mom's 80.
So basically, so that you know, that's going to be, having granted the motion, that's going to be the court's determination of the eviction date and the money that's owed
March 10th.
on March 10th. (2026) at 9 a.m. Anything else? No? Hearing none. Thank you, folks.